All right, just a quick video here. Somebody wrote in my comments section about a case. It's Willson versus First Judicial District Court in Nevada. Now, first of all, I'm not a Nevada lawyer. I'm in California. I don't practice in Nevada. So when I give you information, it's from a California perspective. Although it is part of the Ninth Circuit, each state has its own nuances. And I came to conclude that they were unconstitutional, even though the Nevada Supreme Court has said that they were. This Willson case, by the way, mentions Scott. And if you guys are watching my other video, I pulled the Scott case and talked about it. Okay. It also fails to mention the Hibble case, where it says incorrectly in this opinion that there's no other action on 199.280. That's not true. 2015, the Hibble decision came by. I found that case. So let's just take a look at this case, Willson versus First Judicial District. This one's brand new, February 8, 2024. And there's a lot to be said about this case. So it's a great find. I love this kind of stuff because this is what legal research does. It can completely change the outcome of things. The trial court, the district court, passed on the constitutionality of a question, and that automatically certified it to be looked at brand new, what they call de novo review in the appellate court. Brand new review. It's a pure question of law. We're now going to interpret it. This statute's been around since, I think, 1911, and there is no legislative history on it. There's really very little case law on it. And this court does criticize the statute to such an extent that they're trying to contort it to make it constitutional to avoid invalidating it. The district court did not have the benefit of our interpretation of 197.190. What does that tell you? It's saying, we know why you ruled the way you did, but now we had the benefit of looking at this. Now we're going to tell you what the law is. Now that brings up a lot of very interesting questions. If it takes an appellate court to tell a district court judge what the law is, what does that say about how badly written this law is? I've told you from the beginning, look at my videos from 5 months ago. I absolutely excoriated these statutes as very, very terribly written statutes that are clumsy, awkward, hard to understand. They have both a negligence and a willful component in them. I mean, it's just terrible the way it's written. And if it's terrible, then an innocent person could get busted. And this court is acknowledging that. They're saying that they are now going to limit this statute to a specific intent. Now, just understand there's two types of intent. There's general intent and specific intent. Specific intent are crimes that require a certain state of mind. Burglary, you went in there to steal. General intent doesn't require a state of mind. You just have to do it, okay? And it says shall, which is mandatory, refuse. Refusals are willful. And then they switch from refuse to willful, even though it kind of means the same thing. So you got three parts here, and they're saying, you know what, ignore the due notice. 1911, and they can't find any. Now, when you hear about what's in the legislative digest, legislative history, what they're really saying is they want to go back to the days when the legislature had this great idea to pass this law, and they want to know what the intent behind the law was by the legislature so that they could, as the judicial branch, interpret the intent of the legislature to avoid invalidating the law. That's why legislative history is persuasive when you do statutory interpretation, but it's not conclusive. It's an aid. Okay. You want to preserve the statute if you can, but you're looking for absurd results. If you find an absurd result by interpreting it, then you got to just do away with that interpretation if you can by removing it, from, because we don't want absurd results. We also take an idea called surplusage, which is no statute is supposed to have unnecessary words, and that every word that's in there, it was meant to be there. There's an intent by the legislature to put that word there, so it must have meaning. Okay. And of course, it doesn't define what willful means. So when the word is not defined, you have to then go by ordinary plain language. All statutes are first interpreted according to their plain language. And, they came up with a couple of different ideas. Was it malicious? Yeah, willfully malicious, stab someone. Willful could just be stubborn, Willful could also be just refusal to comply. See, that's what makes these statutes dangerous. That's why I'm telling you I don't like them. You can really read a lot of stuff into them. No legislative history. I told you why, so they can understand the intent of the legislature when they passed this horrific turd in 1911. Other jurisdictions appear split on whether similar statutory offenses are general or specific. Here is, okay. And so it says, from guidance from other jurisdictions, it tends to lean towards a specific intent. Fine. By the way, right here, the other statute Chille was charged with, we note that NRS 199-280, which prohibits a person from willfully resisting, delaying, or obstructing a public officer, is similar but not identical. That's true. However, there is no Nevada case law interpreting this. Not true. If we go to my video, we have the Hibble decision. I think it's 2015 case. They missed that. Now, what did I tell you about vagueness concerns? That's always a ground for attack. Remember, when you attack a constitutionality of a statute, it's not, oh, it's unconstitutional. Oh, there's issues that we have to talk about. You have to splice it up. And each one drops down in its own bucket. Vagueness. What the heck is this statute really trying to tell me to do? I am a person, I think, of ordinary intelligence. And if I can't understand it, then what are you supposed to do? And you're not trained in the law, okay? The district court got this wrong. So we're going to have to tell them how to do it. But we don't know how to do it. So we're looking around for other courts. And what did they say about the other courts in other jurisdictions? It's split. It shows you how bad the statute is. Because everyone is looking at this and they're kind of jerry-rigging it to get to what they think is the right result. But that all starts from bad writing. Thought, well, we'll just cut it down to specific intent. You had the intent to do it, that limits it. Now we're taking the statute as badly as it's written, and we're going to create a new version of it. What sucks is that when you read the statute, unless you pull this case, you don't even know that that's what happened. So one huge criticism of this opinion is, unless somebody pulled this case, how crazy this is. You pull the statute that you're being charged with and you read it and you're seeing the three parts and you're like, man, this statute's got me nailed. All I did was ask the cop how far back, or I was only talking to the cop for 30 seconds and he already busted me. And you don't have Lexis or Westlaw like I do. You don't have this ability to do legal research. You're not an attorney, or how to even interpret case law. And you just go to you just go to the conviction, you take it, and you feel like you got to take the L. And you go to trial and you wind up getting convicted. You get to the situation where you want to avoid the cops because they have too much discretion to bust you. And this opinion talks about that. It says a specific intent requirement would mitigate vagueness. Well, that's true. Now, here's where everyone is talking, but I want you to pay attention here because this is not the end all be all, and they're admitting that. NRS only applies to physical conduct and fighting words. Fighting words are unconstitutional. Physical conduct, blam, body check, bam, bam, we're going to hit you. Well, it really, that's obvious, but then they explain why it maybe isn't obvious. It says, strictly speaking, the spoken word may slow, hamper, prevent, or impede a public officer from performing their duties. So those aren't fighting words. Cop looks at you and says, step back 10 feet. And you just stare at them with a menacing look. You haven't said a word. That's expressive conduct. As this opinion says, no legislature can draft a statute that covers everything, which is why well, it says here, so a spoken word can be just as effective in impeding an officer in the discharge of his duty as if the orator, sick, means misspelled, had grappled with the officer. Yeah, have you ever had someone look at you with a menacing look, and then you kind of walk across the street, go the other way? He hadn't really said anything. If you wanted to charge him, you would say, what are you busting me for? I didn't say a word to you. Or maybe he only said a few words, but they had an underlying meaning to them. It says, as such, NRS may reasonably be interpreted as prohibiting speech that hinders, delays, or obstructs a public officer. Prohibiting speech. Now, try to figure out what that means. Remember, start with the premise that we have a turd, and we're trying to make this turd into something that is more palatable. I don't like that word. I don't want to invalidate it. It's been around for 100+ years. It must have some value somewhere, especially in law enforcement capacity. Because remember, officer safety. Remember officer safety? I was telling you about the cases I looked at. They're all about officer safety. They clearly want to keep the cops in a situation where there's officer safety. So they're afraid to invalidate the statute. So they're trying to cut it down. It's through this little disclaimer within, it's not packaged as a disclaimer, but that's what it's saying. They're really saying, well, it could reasonably be interpreted, may reasonably be interpreted as prohibiting speech that hinders. So did Chille say anything that would effectively hinder the cop in doing his job? If you look at my video, I told you the kinds of things that would happen. Was he forcing the cop to repeat himself? Was he delaying the cop and being able to gain control over the situation? Was he doing anything? But they said, no, not so fast. Irritating the cop doesn't count. You're allowed to irritate him. So we have to back away from that now because it's no longer irritation. So what does the cop do? No, it didn't irritate me. It obstructed me. Now what does the appellate department or the appellate court do with that? How do you discern the difference between irritating and obstruction? You just play this word game because we're dealing with a turd. This is a turd. Remember, when you get into logical arguments with people, always be aware of the fact that it could be a circular argument. And when you get on a circular argument or a circular premise, wherever you start, you wind up back where you started again. Hence, it's circular. There is no resolution. When it says here that NRS may reasonably be interpreted as prohibiting speech that hinders, delays, or obstructs a public officer, they're not ruling out speech at all now. They're just saying that speech isn't constitutionally protected. But it very well may be, because like they admit, they can't write the statute to encompass all situations. It says, however, the statute does not explicitly reference speech. That's true. That's why it's bothered me. The term obstruct and hinder may also connote some action or inaction. Now, remember what Chille said, he talked about, I think, in terms of resisting arrest, it's like some physical act. And I said, sorry to interrupt you, Chille, but no, I know you like to think that. I know you guys like to argue that, but inaction, and I was using the stop oil people that hang out in the street. They're not physically doing anything except sitting there in the roadway. And then when they go limp and you got to drag them off the road, that's a form of passive aggressiveness. So passive aggressive behavior, even if constitutionally permissible, because nothing is said, could still be grounds to charge you. So all this does is requires the cop to now be a little bit more creative in how to nail you with this turd of a statute. In light of the constitutional concerns previously identified, the canon of constitutional avoidance obligates this court to further limit its application to physical conduct and unprotected fighting words. Anyway, it says, although the specific intent requirement narrows and clarifies the statute so as to bring it at least closer to being within constitutional parameters, it is not clear that this requirement would wholly resolve the constitutional concerns presented by the statute. Once again, we're back to the turd and we're on this circle. They're trying to make the circle smaller. Before it was very expansive. Now they're contracting it like an orifice. It's closing up. But it's not going to be fixed. Notably, the specific intent requirement would not prevent its application to constitutionally protected speech. Well, they've already said that. Okay. But the specific intent requirement also may not, in and of itself, provide sufficient guidance to law enforcement in the statute's application. And that is true, because you're explaining this all to the cops, and they all have their different interpretation of what this means, which means different people get busted for this. Different people can be busted for, one guy, 20 seconds of obstruction, that's enough. Another guy, 2 minutes. We're still back to the same problem. It would not cabin the excessive discretion the ordinance provides to officers. And by the way, guys, I did talk about Scott in my video. I interpret it as applying only to physical conduct and fighting words. And now remember, whenever you read an appellate opinion, it could look very, oh, hey, here's what it says. And then you find out that there's two sentences that essentially negate that or expand it. But we note it does not require the use of force or violence, and that a person's action blocking the path of an officer, think of stop oil, or inaction, refusing to obey a lawful order, think passive aggressiveness, may, which means it could, constitute physical conduct that hinders, delays, or obstructs an officer. So you're right back into it again. Okay. The cop makes the decision as to whether or not you're busted. You get written up. Then it goes to a supervisor who says, wait, hold on a second. Now, you know, this is what happened. He was delaying you and obstructing you because he was refusing to cooperate with you. It didn't matter that he called you a mofo, SOB, whatever, because at the same time, we have to make sure that we have a specific intent. Well, he did have a specific intent. Gosh, don't you just know it? His specific intent was he refused to cooperate with me. So we're back again with this statute where it leads to nowhere. Then it says, having determined what it prohibits, we now consider another constitutional test, which is being facially overbroad. Facially overbroad is just another way of saying it's so vague, it's so expansive that it can sweep up anybody into it. I've been arguing that since 5 months ago. And it goes, it's strong medicine because if it's true that it's facially overbroad, then it's got to be struck down because it can sweep up people for different reasons under different situations. But courts don't like striking down those kinds of laws. However, this is what they're saying, as construed by this court, as we now see it 113 years later, it does not apply to protected speech. It applies only to physical conduct and fighting words. So once again, they're trying to save the statute because they admit as it's written, it is overbroad, but not now because they've sprinkled magical dust on it. This limitation positively distinguishes it from the ordinance struck down in Hill and Lewis. The mere fact that a person's speech may at times be implicated incidentally in the enforcement of the statute does not render the statute facially overbroad because we acknowledge there's going to be some talking usually of some kind, so speech is usually involved. And there's the Scott case that I discussed in my video from 5 months ago. And Scott had really broad discretion. I mean, one guy just basically mouthed off to a cop, I think 3 times as deputy sheriff by just interjecting himself into it, by questioning the guy. My dad's a lawyer, that kind of stuff. And they struck down that local ordinance because it was just really easy to bust somebody with that. As such, law enforcement has no discretion to arrest persons or for protected speech or for physical conduct that is merely annoying or offensive. What was the words that his new lawyer used? He used obnoxious. And I told you that was a really good choice of words. That would be something that slides right through. Annoying, offensive, obnoxious. It all fits. Score 1 for Mr. Oram. I like the way he said it. Now I'm seeing the case law, and it would line up with that. So if the activity of Chille is deemed obnoxious, well, that doesn't get him a free pass either, but it gets him closer to collecting go and getting his $200, you know. But there's still other things of the case that could still just end all of this for him anyway. The issue that remains is whether her actions and words, in fact, constitute protected speech. Then you got to look at it as a series of events that are going to be carefully parceled out. And then you're going to say to yourself, is there still, after you exclude, you know, with this new requirement of how they're interpreting this law, if you exclude that all out, is there still enough left to convict Chille? This is tantamount to the appellate court saying that this is a crappy statute, but we're not going to invalidate it. There could be political reasons. Maybe the law and order aspect of it, they would have nothing to fall back on. The proper approach in my book would be for the legislature to draft a new law, okay? Not something that just basically is so widely drafted that it's so vague that you need another court to tell you how bad it is. Because remember, someone got convicted under this statute already. And we don't know how many others, but police tend to arrest people on obstruction and resisting arrest charges. So I would assume this thing has, been used quite a lot. Is all these individuals who may not have the money to hire a lawyer, the cost of this appeal, $25,000, $30,000, $40,000, easy. And you lose the appeal. What do? Go over there and then go to the, to the Ninth Circuit for a misdemeanor conviction. I mean, so it really keeps the record from being developed because there's so few challenges, because most of the people that get busted for this don't have the money to mount an attack.